Thank you. All right, counsel.
Good morning, may it please the court. My name's Lewis Jenkins. I'm here for Mr. Wortman this morning. I'd like to reserve 5 minutes for rebuttal, please. And I don't think I'm going to have any problem with the lights this morning because I doubt my initial argument will take 15 minutes. As the court is well aware, this case was dismissed. This is a post-conviction, a petition for post-conviction relief, and it was summarily dismissed by the Shelby County Circuit Court. Our argument is very straightforward and doesn't require me, thankfully, to go into much subtlety of argument. I think I have taken the PDF program and copied and pasted into the brief in 2 places an image of the order that was entered for summary dismissal. And I believe that, number one, that order does not take account of the case law on the constitutional tolling of the statute of limitations in post-conviction cases. And 2, we believe that order does not comply with Supreme Court Rule 28, Section 6, such that Mr. Wortman filed this case pro se. Since he filed it pro se, Section 6 of Rule 28, so Supreme Court Rule 28 requires that it not be dismissed for any insufficiency of form without an opportunity to amend it once counsel is appointed. I think that that should have been done in this case. Mr. Wortman set forth a colorable claim. As the state acknowledges, he mentioned constitutional tolling in his brief. He may not have gotten the technicalities of the constitutional tolling correct, as has been pointed out by the state of Tennessee in its brief, but he did mention it, and he explained what had happened. He explained, first of all, with constitutional tolling, the very first ground for constitutional tolling is that the opportunity did not arise to bring the case within the normal time period because the cause of action did not arise or the facts did not occur that would constitute the cause of action until after the initial time period had passed. And sure enough, that's what happened in this case. Mr. Wortman did specifically say in his petition that the facts constituting his cause of action under the for post-conviction relief did not arise until after the original 1 year had passed. Given that.
So, Mr. Jenkins, that's.
Yes, sir.
With constitutional tolling, there are also other requirements as well. So the situation has to arise outside of the petitioner's control, maybe arguably here. But the petitioner also has to still pursue his rights or her rights with diligence. As I understand it here, parole was denied in 2019. Post-conviction petition was filed in 2022. Why is there a 3-year delay there? What's the argument that the petitioner was pursuing his rights with diligence?
Well, I think as he laid out in the petition, Your Honor, he was trying to address that maybe by means that were insufficient, but on his own he was trying to address that. I think that under the rule is almost like a Rule 12 motion in a civil case, you know, in the case that I cited in our reply brief, i.e. that there's no set of facts that would entitle him to relief. I think the answer to that question is that with the case in this procedural posture, under Section 6 of Supreme Court Rule 28, he's required, once he's set forth a really skeletal claim that demonstrates that there's no set of facts under which he could be entitled to relief, that invokes subsection 6A4B, which we've quoted in our brief, that he's required to be given an opportunity to amend with the assistance of counsel and set forth more precisely what his grounds are.
What would be the set of facts that would show that he's acting with diligence when the
I think the set of facts that would
the time is a 3-year period?
I'm sorry, I didn't mean to interrupt you, Your Honor.
What are the set of facts that would show that he was acting with diligence, even if we view the evidence in the light most favorable to him?
So, you know, I go back to that Foley case. It was several years after and the Foley's a little bit different because the law changed 3 times in the first 3 years after the plea agreement was entered. But even after that, it was another 3 years before the petitioner in Foley sought relief. And what he demonstrated in that case is that, number one, he'd been trying to get the assistance of counsel and he'd been given incorrect advice a couple of times, and that he was trying to pursue that by another means. And I think that would be the only set of facts that I can think of right now that would entitle him to relief, is that he could demonstrate, and we don't know what that is because of the way that this was summarily dismissed, even though he said, I've got a tolling claim. And it was summarily dismissed without giving him an opportunity to expand on that. But I think if he could demonstrate that he was following he was engaged in the administrative process, trying to address that in another manner, that would be sufficiently active on his part to demonstrate that he had done all he could do, because I think that's exactly what was going on in Foley. Obviously, it was a long time after the law changed the second time, where it was changing back to require that Mr. Foley register under the sex offender registry. It was a long time. I think, if I remember correctly, I think it was 3 years in that case between the time the law changed the second time in 2012, I believe, and when he brought his petition. So I think it would be incumbent upon Mr. Wortman to demonstrate that he was pursuing the rectification of what he claimed was the breach of the plea agreement in some fashion.
Is the claim right? So this is what's confusing to me. So it looks like in 2015 he's given a 30-year sentence. The claim is that he will be eligible for parole and have a parole hearing 9 years after the fact. And for a reason that's not clear to me, he apparently has a parole hearing 4 years later. If the original agreement, as he asserts, was that he would be paroled after he had served 30% of the time, it doesn't seem like the claim is even ripe now here in 2023.
Well, I can only speak to the fact that they did give him that hearing, Your Honor.
But the original agreement was that he would be paroled after he had served 30%.
I think also,
ripe?
I'm sorry.
No, excuse me, I don't mean to interrupt.
I'm not
is the
meaning
claim
to
ripe?
interrupt you. I'm just misinterpreting.
You're not at all. You're not interrupting me at all. But thank you for the consideration. Is the claim ripe? We still have, it looks like, a number of years to go, maybe at least a couple of years to go.
So I would address that by saying this, Your Honor. I think that he sufficiently stated that it was his belief that part of the plea agreement is that the prosecutors were not going to oppose his release whenever he got a parole hearing, and that part of what he's claiming is that was part of the plea agreement, and then in fact they did show up and oppose it. So since they gave him the parole hearing, and since he says, under his version of the facts, the state did what it promised not to do, which is show up and oppose his parole, I would say that I would argue that made the claim right. But I understand the computation would not have included that time.
Because the state could still show up at the next parole hearing if it's 30% and say, we don't oppose this and he should be free, assuming we're viewing this the way petitioner views it, and then he doesn't have a claim.
There'd be no breach at that point.
I mean, yeah.
Even under his agreement.
That might be true, but we also don't know on this record when the next hearing is going to be. And for example, one of the things that I think is that I think counsel would help him to do in the petition is to say they had this hearing and they haven't scheduled me another hearing for X date, which is more than the 30%. And so I don't think the state can rely on the fact that the time hasn't passed, since they're totally in control of when that hearing happens, and they chose to go ahead and have it.
I mean, I know the argument is the state is the state is the state, but at the same time, the DA's office has no control over when the parole board grants a parole hearing.
I understand that, but I do not believe it is an excuse for what happened, that one agency of the state doesn't know another agency of the state is doing. If and by the way, I think the piece of the transcript that was attached to the petition reveals that it was not, that was not really the grounds that they were opposing it, that the time hadn't passed, but rather they were opposing it for other reasons that they didn't think he should be.
Is there a dispute as to what the agreement is? I mean, from my review of the record and of the briefs, the agreement seemed to be pretty clear, at least from the petitioner's perspective. And that was after he had served 30%, then he would be released. No breaches occurred unless there's a dispute with the petitioner about what the agreement actually was in the first instance. So is there any dispute about what the agreement was from his perspective?
I'm going to be hard pressed to say right now that my client said something in the petition that was not his understanding of the agreement. If a lawyer had written that petition, I suppose I could say, well, I'm sorry, I misunderstood what he said.
Well, we know that the agreement that he believes was that he would be released after 30% because we had litigation in the Court of Appeals under the Administrative Procedures Act. And in that case, he made the exact same claim. So it doesn't look like in this case that he's mistaken about what the original agreement was. Once again, is this issue ripe for resolution at this point?
I still say that it is, Your Honor, for the reason that I'm not going to go back through that whole argument, but I don't think it ought to be an excuse for the state not to do what it said it would do. In theory, he wouldn't have had a parole hearing or until such time as that period of time had passed. Since the state decided to go ahead and do that, and they came and imposed it for reasons that I don't think were 30% hasn't passed yet, I don't think they ought to have the benefit of that argument would be my position. But I agree that Mr. Wortman said very clearly what he thought the agreement was. I'm only hedging about whether or not there's a dispute, because I bet if you remanded this case back to Shelby County and we filed an amended petition and then we had an evidentiary hearing, I think there would be a dispute by the state of Tennessee about what the exact content of the agreement was. I would expect to hear that.
So there's no corroboration in the plea agreement, in the transcript of the sentencing hearing, any documentation where the state says we will not oppose parole?
That does not appear in the colloquy of the plea, Your Honor, but there is evidence to that effect, which I think Mr. Wortman ought to have the opportunity to put on.
His testimony?
Yeah, well, maybe not just his testimony, Your Honor. So there may be other evidence, but you're specifically asking me if I think it's in the colloquy of the plea agreement and on the formal transcript in circuit court, and my answer to that is I do not believe that it is in those exact words.
Do we have the transcript of the original plea agreement in this record?
We do not.
Right, okay.
We do not,
All right.
no.
What effect does the Court of Appeals hearing have? It looks to me, but it's difficult to see on the record, it looks to me like this exact same issue was raised in the context of an Administrative Procedures Act case. Circuit Court denies relief. Court of Appeals affirms relief, affirms denial of relief there. Is this claim previously determined?
Well, that's you're really putting me to the test this morning, Your Honor. I'm arguing about a bunch of things I don't think the state raised in its brief, but
we're bound by it because these are jurisdictional issues, and so we're bound by each one of these types of
yes, sir.
Of thoughts.
So I would only answer that this morning, if I could, by saying if the court thinks that particular issue, i.e. whether or not either the law of the case or some kind of issue preclusion binds Mr. Wortman to that in some way in this case by that prior decision of the Court of Appeals, I would ask for an opportunity to submit a supplemental brief on that issue, because I don't think the state raised that in its brief. And as the court is well aware, all in civil and criminal cases, all issues related to some kind of issue preclusion or can turn on highly technical points, which I think my client would be ill-served by me trying to come up with an argument standing here on my feet. But I believe I'm competent to come up with an argument if I could have an opportunity to address that, Your Honor.
Very well.
So, thank you.
Mr. Jenkins. State. All right, counsel.
May it please the court, Catherine Decker representing the state of Tennessee. A couple of things. First, right off the bat, Rule 28, Section 6 does not apply, and that rule says that no pro se petition shall be dismissed for failing to follow the prescribed form until he's given the opportunity to have, counsel on an amendment. But this isn't about a prescribed form. This is about the failure altogether to allege any facts relating to due process tolling. So right off the bat, that doesn't apply. But I think it was, so Judge Greenholz has identified the exact issue that's completely dispositive, and that is nowhere in this almost 70-page petition does the petitioner explain the 3-year gap between the event that he claims was the extraordinary event.
So it's the
And when he
state's
filed.
position that pro se litigant acknowledges he's past the statute of limitations, uses the words due process, says I was trying my best. But again, it's a pro se litigant, not trained in how to argue that and explain that doesn't invoke the rule and allow for counsel to be appointed to help further explain that?
And actually, he never says I was doing my best. In 70 pages, he never says one word to explain the 3-year gap. And so that's the question is, and what the question before this court is not on the merits of due process tolling. It's not even, of course, on the merits of
Right,
the
I'm not
claim.
talking about merits.
But on the merits of whether.
If he acknowledges he's late and all he says is due process should toll the statute, that's not enough to trigger the rule?
He has to allege, he has the burden, because it's jurisdictional, he has the burden of saying there's been an extraordinary event. Of course, if he doesn't, the statutory grounds don't apply, so just be due process tolling. So yes, he has a burden in his petition to tell the PC court something about the 2 prongs, which is there's been an extraordinary event and that
so
he's.
There's plenty of cases out there where a pro se litigant literally only checks the box of ineffective assistance of counsel on that pre-printed form. And the court has said that is sufficient to allow for the appointment of counsel to flesh out those ineffective assistance of counsel claims, correct?
Correct.
So why is this different?
Well, it's a jurisdictional question, and the question is, should the PC court have made additional findings before it's summarily dismissed? There is nothing in this 70 pages of petition that explains the 3-year gap. So, for example, if he had just filed the petition, is that enough? Or does he file the petition and say due process tolling without, if the petition were 2 pages? I just don't think that's enough. It's not enough to send this case back to the PC court to make additional findings. This is a jurisdictional question. The PC court can't get past that jurisdictional question to appoint counsel, et cetera, and to have the hearing if the petitioner has alleged absolutely nothing to explain the 3-year gap. In the normal course of things, when there is some reason why this petition is so late, the petitioner would have the words to explain it. I've done this and that and this and that. And I know that his counsel said that in the petition he explains that he was engaged in other activities. He doesn't actually do that anywhere in the petition. He may have been engaging in other activities, but he doesn't mention that anywhere in the petition. And second of all, the fact that he's engaging in other activities doesn't explain why, at the same time, he couldn't have filed this PC petition. He simply it seems to me that his belief is that, well, this fact that the parole hearing occurred after the first one-year statute of limitations suffices to explain all of tolling. But it just simply doesn't explain that 3-year gap.
General, does the state otherwise agree that the first 2 prongs of due process tolling are met here on the allegations? That is, that the claim is later arising and that the circumstance was outside of the petitioner's control? Are we only dealing with the diligence aspect of due process tolling?
The diligence aspects is completely dispositive.
I don't disagree,
Okay.
but does the state concede the first 2 are present otherwise?
I will dispute that for this reason. And that is, nowhere does the petitioner say, it was my understanding that the plea agreement was that the state would not oppose my parole hearing. He doesn't say that was my understanding. And as his counsel has conceded here, even at the plea hearing, apparently that wasn't made clear. He's not saying, oh, well, at the plea hearing, I was led to understand that the state would stand down at the parole hearing. What he's telling this court is when you look at the piece of paper that's the memorandum of understanding, it says I get released at 30%. But this court can look at that piece of paper. That is not what it says. So it's not a question of what he understands it to be. He's simply misrepresenting what it says. And so for that reason, I don't think he has actually alleged an actual extraordinary event. I just don't think so. I think he has said, I wish the facts were different. But we can look, we have the pieces of paper, we have the judgment where it says 30% eligibility. We have the memorandum of law that 3 times says eligibility. Those are the facts. Him saying those are not the facts does not create a fact. It just is his mischaracterization of the actual facts. So I would even dispute that there is an extraordinary event, because he has grounded that allegation on a mischaracterization of facts that we can see on a piece of paper. But as I said, I think this entire thing can be disposed of because he just doesn't at all address anywhere in his petition the diligence prong. So for that reason, the PC court had no obligation to make findings because there were no facts from which to make findings on that diligent prong. And even if this court thinks the PC court should have gone further in its order, there's no reason to remand because this court has all the facts necessary to say that the petitioner has not alleged the diligence prong and has not met his burden of establishing due process tolling. So unless this court has any further questions, I will just ask to affirm the PC court's order.
Thank you, counsel. Mr. Jenkins?
Yes, sir.
I know you said you weren't going to take but 15 minutes. Did you reserve some rebuttal?
5 minutes, yes,
Okay,
sir.
good, all right.
And
You got
I
some
would
time.
I might point out that if left to my own devices, I wouldn't have taken the entire 15 minutes.
Well, let's not leave you to your own devices here. So the state says that with respect to the first 2 prongs of due process tolling, one, an extraordinary event that arises after the running of the statute of limitations, and 2, that's outside of the petitioner's control, the state argues that the petitioner just has mischaracterized the facts, and that on the face of the record itself, this court can determine that the petitioner has mischaracterized the facts. And so irrespective of whether there is diligence in the pursuit of the claim, petitioner can't get over the first two steps. So what would be the best response to that?
I offer three things in response to that. Number one, that's obviously not what the trial court thought, because in its order, the trial court didn't even address the tolling issue. It did not address that, even though it was specifically addressed in its order, in the petition. And I get that his references to tolling might have been at times, a couple of times loquacious, and at other times not quite right on point. But that's not the test. The test is whether or not he's just simply set forth enough. This petition is repetitive. It contains a bunch of irrelevant information. It didn't need to be 70 pages long. It probably could have been 10 pages long. But he deserves the opportunity, since he got the core of what he was trying to say into the petition, he deserves the opportunity to have a lawyer help him draft that. And get it right. That's number one. Number two, that's a fine argument for the state to make on remand when we're talking about the merits of the case. It's not right now, because everything in the petition has to be read in the light most favorable to the petitioner. And I gave the court this quote from the Charlton case, 987 Southwest 2nd, 862, page 865. The pro se petitioner must assert a basic theory of relief under the new statute at the preliminary stage. The trial judge is required to determine whether it appears beyond doubt that the petitioner could prove no set of facts in support of his claim which would entitle him to relief. I'll grant that he has not said things in detail that can be better said, but the only issue right now is whether or not he deserved the opportunity to do that based on what he did file. And his mention of those things is in fact enough to get him to the next step. Now, after the redrafted petition is submitted and the trial court looks at it, then maybe the trial court is in a position to do that. The third thing I would say is that that's just not something that is appropriate to be determined, bless you, Your Honor. That's not something that's appropriate to be determined for the first time on appeal, Your Honor. I think that the Rule 28 is there for a reason, so that the trial court can look at the petition in detail and then set forth a list of things that govern why it's dismissing a petition summarily. And in this case, the one argument, and I know at times he expressed it in a way that probably, there's some, I think, much of what he was thinking is clearly set forth, that it was based on this idea that maybe the 6-year statute of limitations applied because there are these cases out there that talk about plea agreements being a kind of constitutional contract. And so that may be a misplaced argument, but at least in a couple of places he mentioned the right argument. And so that is an issue that should have been dealt with by the trial court and should not be dealt with for the very first time in this court. So those three things, I think, are my best argument. And he must say 50 times in this thing that the state has breached its plea agreement, and it's just not true. I mean, he may have said it ineptly, okay, at times, but ineptitude is not a reason to deny the petition. It's a reason to get somebody who's apt to, if that's a word, to help him get the thing in order. And so I don't think that argument carries any water at all. Thank you. That's all I have.
Thank you.
Thank you.
You're good, aren't you? You're fine, aren't you?
Absolutely. Yes, sir.
All right, Madam Clerk, you